just a very quick introduction of myself and SEBAveristy. So my name is Marcel Harman. I'm the head of SEBAveristy of SEBA Bank here in Crypto Valley in Zug. We're from Switzerland. So we bring you actually all kind of educational content and activities such as today's Sunset event. Make sure you check out our website. As I just said, all past events are recorded as well. We had blockchain technology and social impact, blockchain scalability together with Polkadot, very interesting topics. Also interesting upcoming events like digital estate and how to make sure you don't lose your crypto in case something happens to you, from Alexandra from MME. So all together interesting things. But yeah, today we are here for blockchain and privacy compliance. Thank you, Marcin Zarakowski, legal counsel of Lisk Foundation, for joining today and to give this interesting lecture on the most critical problems with blockchain technologies, privacy compliance. Very warm welcome. And yeah, I think we gathered a couple, and I think a few more will join. But I'll hand over to you, and then you can start.
Okay, thank you, Marcel. First of all, nice to meet you, everybody. As Marcel mentioned, my name is Marcin Zarakowski. I'm a legal counsel at the Lisk Foundation. I'm also a Polish attorney at law. I specialize in IP, IT, data protection law, and also various aspects of blockchain technology. I'm also a co-chair of the privacy working group of INADBA, where INADBA stands for International Association for Trusted Blockchain Applications. And I'm also one of the co-founding members of ThinkBook Tank, which is an association of European lawyers specializing in blockchain. I will try to share my screen now and in my presentation. Please confirm if you can see that. Okay, please confirm if you can see the presentation.
Yeah, we can see the screen.
Okay, perfect. Then, as mentioned, today's presentation that I want to give is blockchain and privacy compliance. Here's the agenda. It looks short, and I hope that I will not take too much of your time and that you will not be bored. But I want to discuss some of the issues that are crucial for privacy compliance of blockchain technology and blockchains in general. At the beginning, a little bit of introduction. As mentioned, I'm the co-chair of the privacy working group of INADBA. And within this working group, we launched, as one of our projects, we launched a survey, which was circulated among different industry members, organizations that are developing or already implemented blockchain projects. And one of the questions that we've asked was the one that you see on the screen now. Have you made efforts to meet the requirements of the applicable privacy regulations? And as you can see, the vast majority of the respondents answered positively. The report, by the way, should be the results of the survey and the report in which we analyze the results should be published this week. So I also recommend you to check it. It should be available on INADBA's website. Another question which we also asked, and there's no mistake, the results were exactly the same. So the same number of respondents are answered yes. Is meeting the requirements of applicable privacy regulations a strategic priority? For example, addressed and prioritized at the C-level. And again, almost 90% answered yes. Well, these two questions. Yeah, okay. There was an echo. Well, these two questions show that, well, privacy compliance is important for blockchain projects. I want to focus today on the GDPR, and my presentation will be done having in mind the GDPR and its applicability to blockchain technology. Why GDPR? Well, the GDPR firstly stands for the General Data Protection Regulation. It's an EU regulation which is directly applicable. So in comparison to EU directives, it doesn't require any implementation by the member states. And since, as you will see further in this presentation, its scope, both material and territorial, is really wide. And the moment when GDPR came into force in 2018, in May 2018, which you may recall, and because before that we were bombarded with all those notifications and emails sent by different e-commerce platforms informing us about GDPR, because it sets basically a global standard. Because of importance of the EU market for the world economy, for different service providers, not only the companies that are located in Europe, but also outside of the EU comply and try to comply with GDPR when it comes to processing of personal data. Why is that? As I mentioned, because of territorial scope. Because GDPR applies to processing of personal data when controller or processor is established in the EU, and irrespective whether the processing takes place in the EU or not, or another case where data subjects, so basically the users of different services, are in the EU, and the controller or processor doesn't have to be located in the EU. So just take, for example, SEBA Bank, which is one of the hosts of today's it's a host of today's presentation and today's webinar. Is a Swiss bank, but whenever they try to offer its services to, for example, EU citizens, they also fall under the scope of the GDPR. I want to introduce you to a few important actors under the GDPR. Well, data subjects are basically people whose personal data is being processed. It's important to stress that they are natural persons, not legal persons. So when we talk about and when we discuss processing of personal data, and the GDPR applies only when personal data belongs to physical, natural people, natural persons, not legal persons. Another concept of a controller introduced by the EU law is basically controller's role is to determine the purposes and means of the processing of personal data. So two important factors, and like why the personal data is being processed, so the purpose, and also means, so how the personal data is being processed. It's also possible that in some situations there will be more than one controller, but only if in such case we would talk about joint controllers, but that applies only if those controllers, more than one, they jointly determine the purposes and means of processing. It's not so easy because sometimes, even if you have that one is determining purposes and the other is determining only means, it might be arguable whether this is a joint controllership. And the next actor is a processor. So what processor does is just processes personal data on behalf of the controller. Just to give you an example, think of a company. Let's maybe take an example of SEBA Bank. Obviously, SEBA Bank employs and a lot of different employees, and they might also try to search for new employees. So therefore, they try to outsource the headhunting process to a job agency, and this job agency, when they process the personal data of the applicants, they do it on behalf of the controller, but they are a separate entity. So in that case, they would be a processor. And the last actor is the Data Protection Authority, which is the independent public authority that supervises through investigative and corrective powers the application of the data protection law. We usually have at least one in every EU member state. This concept is not reserved only for the EU. In other countries which are outside of the European Union, we also have data protection authorities, for example, in Switzerland or in California, in Brazil. And these institutions, these authorities also exist. So before we start also, it's important to determine what exactly is a processing of personal data. This is a crucial concept. Without processing of personal data, the GDPR would not apply. So what exactly is a personal data? What exactly is personal data? Personal data is any information. And I also underline it here because, as you will see, it basically can be any information which is relating to data subject and allows for his direct or indirect de-identification. This can be the name, surname, ID number, location data, but also an online identifier. So your nickname, your number that you sometimes use in different online services. All these information, if they allow to determine, to de-identify personal data subject, they are considered personal data. But also some other information which is maybe not so straightforward, like email address, photos, and this is an important case. If somebody takes a picture of you and it's clearly to distinguish you from the other elements on the picture, this is a personal data. Your education history, so your records from your university, it also can allow, sometimes with addition of another data, to identify you. Your phone number, even your handwriting. So if your handwriting or your signature, if it's so unique that it's possible to identify yourself, that's also personal data. What's interesting, and it might be also relevant for blockchain, as you will see later on, also IP addresses, whether they are static or dynamic, they also are considered as personal data under the GDPR. Your cookie IDs, so whenever you enter, I guess most of the websites nowadays, they install cookies on your device. You are assigned with kind of a cookie ID. This also is considered personal data. Your mobile device ID. So if you connect to different services using your mobile phone, a mobile device ID is usually shared with the service provider or the server. It's also personal data. So as you see, the concept of personal data is really, really broad. But what is actually processing? Again, the concept here is broad as well. Any operation or set of operations which is performed on personal data. It can be just analyzing the data. It can be sending it further. It can be even saving it on servers on your hard drive. This is considered as processing of personal data. So when you merge those two concepts, you see that the material scope of GDPR, it's really, really wide as well. Then the question, I would say more rhetorical one, but does the GDPR apply to blockchains? The answer is yes. So firstly, wallet addresses, public keys are personal data. In most cases, transactional data is also personal data. There is this division between public keys and transactional data. I will explain that a little bit later, what exactly transactional data is. What else? Hashes might be personal data if they allow for at least indirect identification of data subjects. How about processing? Addition of personal data to a blockchain and its continued storage. So of course, as you know, one of the incremental features of blockchain technology and blockchains and decentralized ledgers is that they are immutable. So once you save or store certain information in the blockchain, they're supposed to stay there forever. That's the rule. Of course, there are exceptions. So even if you store it there, and this is considered as processing. Same if you execute blockchain transactions. So if you are sending different cryptos, and of course, cryptos, as we know, the public keys are personal data. This is also processing. And since most of the blockchains, they have a consensus mechanism which determines how blocks are forged and how new transactions are accepted. Then whenever personal data is involved, and as you know, public keys are personal data, this also is considered as processing. Something that I've already mentioned. So if we have blockchain networks for only legal persons, and there are solutions of this kind already existing for different consortia, for financial institutions, they fall outside of the scope of the GDPR. Why? Because there's no personal data when we talk about legal persons. And then, like I mentioned it, and I just stated that public keys are personal. Public keys are considered as personal data. Why? I mean, when we look at public key, it's just a string of letters and digits. It might be really hard to determine to whom this wallet this public key belongs to. But actually, when you think of that this string of letters and digits, if you add additional information to that, this may allow for disclosure of that subject's data subject's identity. To give you a few examples, that such additional information may be voluntarily disclosed by the data subject. There are people that are requesting donations and payments online where they put their name, or it's easy to know, determine who they are, and they also provide for public keys and wallet addresses to receive donations. Whenever you register to a decentralized and regulated crypto exchange or another crypto asset service provider nowadays, because of the anti-money laundering regulations that are applicable, you're usually requested, at least at the beginning when you are doing the onboarding process, to disclose your information, to do the full KYC anti-money laundering information. So the crypto exchange, the crypto asset service provider, is storing all those data because the law requests him to do so because of anti-money laundering or maybe tax purposes. But with this information, in addition to your public key, the crypto exchange can easily determine your identity. Same thing can happen with authorities, because authorities can request these regulated entities to order them to provide this kind of information. Therefore, altogether with your public key, authorities could also be able to determine your identity. And also something that it's quite popular, and there are a lot of different service providers that provide services of that kind nowadays, of analysis of the chain analysis. So it's possible to verify the history and the pattern of previous transactions executed from particular account or from particular wallet. And therefore, seeing this pattern and having the connections with other public keys, other wallets, it might be possible to determine, or at least narrow the scope of potential people, individuals, to determine later on the exact identity of data subject. So these are the examples of information which connected to the public key can allow for disclosure of the data subject's identity. All this leads to a conclusion that, well, public keys are certainly not anonymous. And if they were, they would fall outside of the GDPR scope. But such situation where certain piece of information doesn't disclose the identity of the data subject immediately, but requires further information, additional information, this information or this data, types of data are called pseudonymous. How about, I mentioned also before that there is this division between public keys and transactional data. So what actually is the transactional data? So transactional data is all other data which is not a public key. When you can think of a transaction, when you're sending a transaction, or there is a transaction approved on a different types of blockchains, apart from the public key, which is necessary for the exact transaction to be executed, it's possible to add certain additional information. Whether for certain types of blockchains, you can try to upload different files. You can store hashes. You can store different documents. All this would be considered transactional data. And there are different ways, of course, of storing this transactional data on blockchain. It can be in a plain text. So you can basically store personal data like my name, your name, on a transaction, and then like execute a transaction with this as additional information, and it will be stored on a blockchain. It can be also encrypted. It can be hashed. And actually personal data can be stored off-chain, but there might be a hash pointer that is stored on the blockchain. So this is also a possibility, one of the options. Here, I think I mentioned this on the previous slide, or maybe the slides before, that some data might be pseudonymous, some data might be anonymous as well. And what actually is, like, when we consider personal data to be anonymous, well, if we have personal data, let's take my name, for example, and if we alter it in such a way that it's no longer possible to identify myself, and it's done irreversibly, so it's impossible to reverse this process. This is called anonymization. As a result, as an outcome of such process, the result is that the data is anonymous, and therefore it falls outside of the GDPR. One may think, okay, so that might be actually the solution. If we are so concerned about putting personal data on a blockchain, why don't we just anonymize everything, and then GDPR doesn't apply, we don't have to worry about anything. The problem is that it's not so easy. Not to say that maybe it's even possible. The GDPR, in one of the recitals at the beginning, before the real articles of the GDPR starts, says that, well, to determine whether a natural person is identifiable, an account should be taken of all the means reasonably likely to be used, either by the controller or by another person. Here, the concept arises is in order to determine if a string of certain data is anonymized, we should take into account all the means reasonably likely to be used. The question is, like, who exactly judges that? So who exactly will tell us what means are reasonably likely to be used? Is it our subjective opinion, or is there like a pattern, a model person that we should take into account, what that kind of an expert would do to measure that? There are a lot of questions arising here, so that the GDPR doesn't provide a clarity. There's one concept how to do it, like a risk-based approach, so which is more balanced, and it allows it's more in favor of different options that provide for anonymization. And another concept is like a zero-risk approach. So if all the means, if there is a one way existing, or maybe possibly existing in the future, which you should also maybe take into account, that the vast development of the technology that could allow to de-anonymize the data that we assumed was anonymized, but apparently it wasn't. The data is not anonymized. And actually, the bolded part here is the Article 29 Working Party, which was an advisory body before the GDPR came into force. This advisory body was composed of representatives of data protection authorities from different EU member states. They were issuing guidelines, interpretations of data protection directives back then, and different other laws and regulations. Now it was changed and to European Data Protection Board. Article 29 Working Party issued guidelines, and in these guidelines, they really advocate in favor of this zero risk approach, which is really, really strict. Then, as I mentioned, it might be possible that taking into account the vast development of the technology, quantum computing, big data, machine learning, AI, and all the technologies that we cannot even take into account at this moment because we are not aware of them and that they are being developed. All this together can actually lead to a conclusion that maybe it's impossible to anonymize the data to such extent that it's impossible, that is then later on possible to de-identify it. I'm in favor of this opinion that we are now leaving so many traces by different means, in different venues, using different services, that there will be always possibility to collect all other data and try to de-anonymize the data that we thought might have been anonymized. As those methods I mentioned, how you can store the data, store the transactional data. One was in the plain text. The other option was to encrypt it. Then the question arises, would that be enough if we just encrypt the transactional data? Would that satisfy the requirement of anonymization? Here, in Article 29 Working Party also answered that in one of its opinions, that although it raises the confidentiality of the data, it's still technically possible to reverse the process because the holder of the encryption key could always still read the data. And this key can be passed to other people, can be shared with others. So technically, it will be always possible to decrypt the data. How about hashing? Simple hashing will also not automatically make personal data anonymous. It will be pseudonymous because technically, again, even though in accordance with the current knowledge, it would be extremely hard, not to say impossible, to do it. The advancement of the technology leads to a technical possibility that, well, maybe it will be possible one day. And taking into account the approach that we saw before, the zero risk approach, Article 29 Working Party is saying, well, this hash data is not anonymous, it's pseudonymous. There are some questions arising whether salted or peppered hashes, so hashes with some additions of another data, could be considered as an option. And yet we still lack the regulatory guidance in that regard. There is no case law which would confirm this. I also mentioned that there is a possibility and actually there's a recommendation also to store personal data off-chain. So we try to, one should refrain from storing any personal data on-chain if it's not necessary. But if the projects and the architecture of blockchains and the architecture of different blockchain applications should be designed in such a way to rather not store any personal data on blockchain. So therefore, the data should be kept off-chain, but due to the hashing function, a hash pointer could be then stored in blockchain. Why is it so advised? Why is it so good to do it in that way? Well, since the personal data as such is stored outside of the blockchain, well, the controller can exercise its duties and recognize data subjects' rights. For example, can erase the personal data, can modify it whenever it's necessary. Well, again, I mean, the personal data, the core of it is stored off-chain, but this hash pointer is still left on-chain. As I mentioned here, Article 29 Working Party is saying, well, hashing would be pseudonymous. So a pseudonymous data is still considered personal data. So what happens? How we consider this hash pointer stored on the blockchain? Here again, we lack the regulatory guidance. We don't know what the regulator, how the regulator would assess this. But there was a joint paper of the Spanish DPA, Data Protection Authority, and the European Data Protection Supervisor, released last year in October. And over there, if you take a look at that, there are certain options that, when implemented, could allow, at least in the opinion of the authors of that paper, could lead to a privacy compliance of such a concept. Well, again, it hasn't been confirmed. Well, the EDPS is the EU body in such a way that, well, it supervises the European institutions and how they comply with the GDPR. But yeah, it might be one of the sources of information if you are designing the blockchain and you would like it to be privacy compliant. What are alternative options? There are some alternatives discussed by the experts that could help to ensure privacy compliance of blockchains. Well, stealth addresses. This is basically using a new wallet, a new public key for every single transaction. This is not also a perfect solution because with the properly done on-chain analysis, you could still, it is still possible to determine the actual personal data, the sender. Another option, and this one actually is endorsed by the Article 20 and 29 working party, is noise addition. So to personal data, before it's hashed, before it's encrypted, we add certain additional data or a lot of other different data, and then we hash it. This might be an option. Zero knowledge proof, so a technology that stays behind, for example, Zcash, could also be one of the options. Ring signatures, so something that is used by Monero. Editable blockchains, so blockchains that you could edit and maybe delete personal data when necessary. Well, when you think of that, well, it might be against the pure nature of blockchain technology, of blockchains as such, because we deem them as immutable. So why would you like to allow for editing them? But in some use cases, it might be actually possible and beneficial. Pruning, so a technology that is limiting the size of the history of the blocks, so that the old blocks after a certain time, after a certain number of transactions, are basically being erased. That might be an option, because then there would be the personal data would not be in plain text or in a simple way be stored on the blockchain anymore. One interesting fact, in September, the EU Commission released a proposal of the new EU market in crypto assets regulation. It will apply if it comes into power, and if it's adopted and then comes into power, and to different crypto assets and crypto asset service providers. And there is a separate section concerning crypto assets trading venues, where it's mentioned, of course, it's still a proposal, that the operating rules of the trading platforms for crypto assets shall prevent the admission to trading of crypto assets which have built anonymization functions. So it might be interesting to see what will happen with zero knowledge proofs, with cryptocurrencies based on zero knowledge proofs like Zcash and Monero, which is based on which uses ring signatures. Of course, it may be facilitated by some other additional services like the travel rule, which is already in the FATF recommendations. But let's see, I just wanted to mention that as an interesting fact. Another issue, apart from the anonymization and pseudonymization of the data and techniques, is data controllership. As mentioned before, when I was describing the different actors under the GDPR, I listed data controllers as one of those actors, and that their role is to determine the purposes and means by which personal data is processed. Data controllers are really crucial for the GDPR. The GDPR as a law, data protection law, puts a lot of different duties, responsibilities, and obligations on the shoulders of data controllers. actually the data controllers are taking care of how the personal data is being processed. Are the first, I mean, to them, the data subjects are addressing their requests whenever they want to enforce their rights. Data controllers are those responsible for data breaches, for example, right? So plenty of different responsibilities that are put on the shoulders of data controllers by the GDPR. So the question is, okay, the question is what, like, whom we consider, like, what actors in the blockchain, in the design of blockchain architectures can we consider as controllers? Because, well, the GDPR, as I mentioned, is really relying on the data controllers and their obligations and duties, because the GDPR was not designed for decentralized structures such as blockchain networks. It constantly searches for a responsible party and asking this question: who is determining the means and purposes of processing of personal data? I think, like, a little bit of history, because as I mentioned, GDPR came into force in 2018, but it was enacted 2 years before, in 2016. But before it was enacted, it was drafted and discussed, and all the legislative process took a few years. So, but even at the moment when it was enacted in 2016, it was still before the big hype of blockchain technology and cryptocurrencies. Nobody back then at the European Union and at the side of the EU regulator was considering that blockchain technology would develop in such a fast pace. And therefore, GDPR doesn't take into account such a structure, the decentralized structures as blockchain network. There is still a lack of any official guidelines and interpretation. So we have nothing to rely on that is coming from the side of the EU regulator, who can over as a data controller in a blockchain network. It's of course less problematic for private and permission blockchains, because over there you can design the blockchain network and it's governed in such a way that maybe a certain entity, central actor could have more powers, maybe to a little bit control the network, to amend some blocks, maybe to erase personal data. Then in such case, most likely that actor would be considered a data controller. But for public permissionless blockchains that are really decentralized, it's really hard to say. There are different approaches towards this. None of them is perfect. There is lack of common consensus in that regard, and it can vary on case-by-case basis. One of the options is that we consider all nodes of the network, of the blockchain network, as data controllers, because they all together, they are building the network, and they therefore determine the means and purposes of processing of personal data. We can go a little bit up, one level up in this structure, and let's say that not all nodes, but all validating nodes or miners in terms of protocols that are based on proof of work mechanism, and that they decide on the means and purposes of processing. Maybe there's another approach that we consider smart contracts and decentralized applications that are running on the blockchain, that they determine and the means and purposes. How about the users of the network? Almost in various public permissionless blockchains, it's possible for the users to upload, to store certain personal data on the blockchain, for example, in the form of a transactional data. In such case, maybe these users of the network, like when they upload certain things to the blockchain, they should be considered the controllers. How about another concept like there is no data controllers? It's so hard to, in terms of really decentralized public permissions blockchains, to determine which actors could be considered as data controllers, that maybe we should just accept it, that it's impossible to determine them. And then we just consider nodes maybe as a part of infrastructure that is running the whole thing. Like we have modems for internet. That's one of the options that exist there. There are some experts are mentioning them in their articles, but there is still no there's any official guidelines and interpretation released in that regard. So we don't know what the EU regulator think about that. One of the last parts of my presentation, data subjects rights. The GDPR provides for certain rights to data subjects. Right to information. So we can request the data controller to provide us with information. What exactly is he processing and how is he processing in terms of our personal data? We should have access to exactly see what personal data is being processed. We have a right to rectification, so we can request the data controller to modify, to amend certain data whenever it has changed. For example, if we got married and it's a necessity to change our marital status to married one, we can request the data controller to modify that. It's important for the processing activity. Whenever when we're requested to grant a consent on certain processing activity, we have a right to withdraw it. We have the right to object to processing, or we also have the right to object to automated processing. It's basically it stops processing activities for a certain moment. We have a right to erasure, this famous right to be forgotten, out of which GDPR is so famous for. And we have a right for data portability. We can request our controller to transfer the data we provided to him to another entity. That's what GDPR says. We have this kind of right. So if we start to think which of these rights are easy to execute on the blockchain network, I think right to information is quite easy. We can verify it on the blockchain network. This is one of the incremental features of blockchains, that they are in most cases publicly available. We can check the ledger. We can see, well, what personal data is there. Right to access, I guess, the same, yeah? Right? We can have access to this personal data. Right to rectification, can we really rectify and modify the data, personal data, certain blockchain easily? Hard to say, right? Rather not. Right to withdraw consent. So if you granted the consent, then we should be able to withdraw. And once we withdraw the consent, the controller should stop the processing activities. Is it possible if the data is already there on the ledger? I guess also not so easily done. Maybe impossible in certain blockchains. Right to object to processing and to automated processing. Is it possible to ask, if we determine the controller, but is it possible for the blockchain to suddenly stop processing our personal data, which is already there somewhere in the transactional data? I also don't think so. It's so easy to be done. How about right to erasure? Even harder, right? Right for data portability here, maybe it would be possible for data controller to create to extract some personal data, still leaving them on the ledger, by provide us with the machine readable format of this data. I think it would be possible. Just to comment on two, I think most interesting rights that I mentioned that are not so easily executable on the blockchain. Right to rectification, as I mentioned, is against the immutable nature of blockchain technology and blockchains. It's more possible to be addressed in private and permission blockchains, where we have this maybe one entity and the governance model allow for that. But in public permissionless blockchains, to do any amendments of the existing blocks would require a consensus of more than 50% of the network. Of course, it depends on the consensus mechanism, but well, it's certainly difficult to achieve and troublesome. It will require a fork, right? And if we would like to make such a fuss whenever we want to amend any kind of personal data, I don't think anybody would like to use this blockchain anymore. Still, even if we do that, the original data could still be stored by the nodes. It doesn't mean that, well, even when after the fork, the blockchain is amended slightly, right? It doesn't mean that automatically the old the old blocks, the history of old blocks is deleted. It still remains, right? It can be due to the fork that still can continue to grow, right? The blocks can still be created. But the GDPR, however, provides for a possibility of supplementary statement, which could satisfy this data subject's right to rectification. So, as I mentioned before, of the example that we could request the controller to amend our data when we, for example, we were our marital status was single, and now we got married. We want the controller to modify that to a married status. In such case, it could be possible because then we just add a supplementary data. At a certain moment, we change our marital status, but it could work only with specific cases where this is possible. And the right to erasure, in the same features as with the right to rectification. It's against the immutable nature of blockchains, more possible to be addressed in private or permission blockchains. In public permission blockchains, especially based on proof of work, the majority of the nodes would have to verify again every transaction backwards and then create a new blocks afterwards. So for blockchain network, it's impossible. It's really virtually impossible. And at the same time, the original data after this fork could still be stored by the node, so we do not achieve this goal of erasing the data. But, well, the erasure as such, the term of erasure, the concept of erasure, it may be interpreted under GDPR in a different way, not necessarily as the total full destruction of the data. There was a famous case that ended up in the European Court of Justice, Google versus Spain, where the court ruled out that Google where the right to be forgotten, right to erasure actually was created, but the court said that where mere delisting of the search results from the Google search engine was deemed sufficient. So the person data was not deleted, but it was virtually impossible for users of Google to find this data. They were not appearing on the search results. Another option is that maybe a destruction of a private key to the encrypted data, which is stored on-chain, could be also possible. So we are not destructing the data, but we make access to it impossible. And this option actually was endorsed by the French Data Protection Authority in its opinion and guidelines on GDPR and blockchain. Maybe if we can come up with other means of anonymizing the data, so we could anonymize the data somehow. Pruning, I also mentioned that. So basically, the old history of blocks is being erased. That could be also an alternative. But when we think of the case of Google versus Spain, where just delisting of the search results was insufficient, not erasing the data totally fully, so the data still exists there, we could maybe move it and adopt this concept to the blockchain world, right? Whenever we want to check the blockchain history, the transactions, most cases we try to use, as at least the common user uses blockchain explorers. So we could maybe address the issue from that direction. So just if the blockchain explorers do the same what Google did, that by just seeking the removal of personal data from search results, that could maybe be sufficient. And one important fact also, it was a case of Google versus CNIL with the French Data Protection Authority, where the European Court of Justice ruled out that this right to erasure has a limited territorial scope to the EU. So this results in search engine should be limited only in the EU, but maybe they could be still accessible from the countries and jurisdictions where GDPR does not apply. Conclusions. Another result of one of the questions that we asked in the privacy survey run by Privacy Working Group of UNADBA: do you perceive the applicable regulations to be helpful or limiting for your business? And small majority said that limiting, and the other half, almost half, said like it was helpful. it shows in comparison to the first results of the first two questions where basically the respondents said that privacy is important to them. It shows that, well, GDPR raises concerns, raises a lot of different problems, and the EU regulators actually do not help in this strive for blockchain compliance. It's with privacy compliance for blockchain because they still haven't released any official guidances or interpretations and opinions. So for the conclusions, use blockchains only when it makes sense. So this is the first and like initial recommendation. In some cases, it is not necessary to use blockchain. Just because it's blockchain, it's popular to use it to market your product that is using blockchain. When you don't have to, please don't, especially if you are processing personal data. Try to conduct data privacy impact assessments for processing activities on blockchain. Verify how your project is really processing the data, especially if you are using blockchain technology. Think of privacy compliance when developing a blockchain-based solution. The GDPR sets a requirement, a principle of privacy by design. So the GDPR imposes an obligation on any controller to take privacy into account already at the stage of designing and developing the solution. Already at this moment, you should take that into account because at the later stage, it might be virtually sometimes impossible to modify it. Collect and process as less personal data as possible. If you have to, collect as less as possible and process as less as personal as possible. This is the principle of data minimization. If necessary, if you really have to collect and process personal data, try to store personal data off-chain. Monitor official regulatory guidelines, interpretation of case law. For example, European Data Protection Board, EDPB, included blockchain in its schedule for 2019-2020. It's almost end of the year. It still hasn't been released, and I don't think it will be released because of Schrems 2 and how important it is. And the EDPB is probably dealing with this decision of European Court of Justice or international data transfers to the US. But it really shows that blockchain is on the agenda. If you are processing personal data on blockchain, inform data subjects about processing activities and their rights. And finally, be aware of the huge fines for violating the GDPR. Depending on the type of violation, it can be up to 20 million euros or 4% of the annual turnover. So the fines can be really, really significant. Thank you. That was the presentation. If you have any questions, I'm happy to answer that.
Thank you very much, Marcin. I actually muted a few, so I'm just quickly unmute them in case they do have a question. Or they can also write in the chat, of course.
Of course, yeah. If you can also write questions on the chat.
Actually, maybe I start with a question. I would have one.
Sure.
How does it affect your daily business at Lisk Foundation?
Since it's recorded, maybe I shouldn't tell, because the data protection authorities can be aware of that. But I think this is an issue that most of the public permissionless blockchains and the entities that are behind them are addressing. We are of the opinion that, well, since Lisk is an entity that takes care of the development of the Lisk network, but we think that Lisk network, Lisk mainnet is decentralized, and we as a foundation, we do not really have means how to control the network. This is one of the features of our blockchain, that we cannot do anything. So we stand on the position that we would like to inform the users. We disclose all that information in our privacy policy. We disclose information how personal data is being processed on our Lisk main chain. We are not trying not to hide anything. This is also an open source project, so all the information are available. But on the other hand, we are waiting for the regulatory guidance. We are waiting to see how the EU regulator will address different issues. because it would also allow us, since Lisk is still being developed, we are still in the phase of developing and working on the project, that maybe we could make some amendments to allow it to be more compliant. And finally, since Lisk is just, we want to create a platform for decentralized applications, we want to provide toolkit for others to build their own blockchains. We would like to know how to build a toolkit which could also allow people, users, companies to build their own blockchains, their own blockchain applications on the top of Lisk, but at the same time you remain compliant with privacy regulations. And because there is no guidance, it's really hard to do that. We are still waiting, we are observing what's happening, we take part in different working groups. Yeah, but without the step from the EU regulator, it's really hard to proceed.
Yeah, totally understand. Makes sense. And also with such education material like today, I think you pinpoint all the different statements you already said now. And thank you very much for the presentations also in the chat. I just received. Thank you. It was a great overview, fundamentals of GDPR and blockchain, what we need to consider when moving forward with the blockchain technology that is in line with the regulation. How can we anonymize data so we don't fall under the GDPR scope? But it's really hard actually to do so. The options we do have to ensure the privacy compliance, our rights we have. I think it was a great overview. Thank you very much. And
my pleasure.
Then, hope to see you soon again.
Thank you. It was a pleasure.
Great.
Bye.
Thanks. Bye-bye.